Hello and welcome to our Lunch and Learn series on HR and employment law topics. You'll find back episodes on our YouTube channel along with this one. Today we're talking about harassment in the workplace, a very topical theme that has been in and out of the news, I would say, for probably nigh on about a decade or more now. We're going to unpack this in our 30-minute session, thinking about the legal side of this topic and the legal duties and liabilities and steps that employers, particularly small businesses that employ people, need to think about taking to comply with some of the newer legal duties that have come into force. So I'm your host, Liz Burley, and I'm going to be leading you through this session. So today we're going to think about these different areas. First of all, the legal definitions and who is protected and who is liable for workplace harassment. We're going to drill down into some of the specific employer legal duties and cover off some special rules on sexual harassment. We're going to bust some myths and misconceptions around what is harassment and what is not. And as always, we'll end with some key takeaways for small businesses and useful resources. So, first of all, legal definitions and harassment in the workplace. The framework of law for harassment at work is the Equality Act 2010. You may be familiar with that. And the Equality Act covers three distinct areas which protect people against unfair treatment in the workplace. And those three areas are discrimination, harassment, and victimisation. Now, for the purposes of today's webinar, I'm not going to touch on discrimination, or not very much at all, because it's a whole area of law that could take us down another half hour. So I am going to think about harassment and victimisation. Now, those two things are defined quite carefully in legal terms, and their definitions don't always match the sort of common way in which we talk about these things in our daily lives. And they may not match the concepts of criminal liability for harassment, for example, if police were to investigate harassment between members of the general public. So harassment at work is defined in this way. It's violating a worker's dignity or creating an intimidating, hostile, degrading, humiliating or offensive environment for that worker. So it's quite a wide and broad definition, and because it's broad, it can encompass many different types of behaviour in the workplace, such as banter, conversation, jokes, compliments. It can encompass images on the computer or in and around the office, even facial expressions. And it's not just about things that are said in the workplace. It can be things that are written, social media, emails, texts, WhatsApp, for example. So it's as long and as broad as it could be. There are no boundaries onto the types of behaviour that can be harassment. What is very important in any legal claim is to look at the context of what is happening and decide whether in that particular situation the behaviour that's being complained about meets this definition under the law. Now, it's important to know that there are three distinct types of harassment in the terms of the law. The first is harassment that's related to a protected characteristic. Now, you may be familiar with protected characteristics anyway because they're relevant to discrimination law. There are 9. They include things like disability, race, religion, sex, sexual orientation, age, and marital status. I think I might have got all 9 there, but I'm not sure if you're counting. Any of the types of behaviour that we thought about just now, if they are relating to somebody's protected characteristic, then that can be harassment and can give rise to a legal claim. The second type of harassment, which is specific and defined specifically and has a whole set of rules around it, is sexual harassment, and that is unwanted conduct of a sexual nature. And that's different to harassment on grounds of sex, because harassment on grounds of sex doesn't need to be sexual. It just needs to be related to the sex, the gender of the person who complains. And the third type of harassment is very specific. It's treating a worker less favourably for the fact that they have submitted to or rejected sexual harassment. So that's a very specific type of harassment or less favourable treatment that falls under the same banner of general harassment. Now, the definition of harassment being as wide as it is makes it very clear that the test for whether somebody has experienced harassment at work is very subjective. In other words, it's seen in the eyes of the victim. If they believe they've been harassed, if they have been offended, if they feel the workplace has become hostile or intimidating because of the behaviour they're complaining about, then an employment tribunal will be prepared to hear their claim. But there is also an objective test, and that means that the employment tribunal will look at the circumstances and the context of what happened to decide whether it was reasonable for the victim to take that offence, to treat themselves as being harassed. So there are two sides to the assessment of whether harassment has taken place, a subjective test and an objective test. So we all know, for example, that, just to give an example of how this might play out, one person's banter or the idea of a compliment might feel offensive to somebody else. Comments in the workplace such as, "Leave her alone, she's feeling hormonal today," or "Cheer up, love," or "You look really nice in that outfit," or "I really like your hair like that," may be very well intentioned. They may not intend to offend, but the person receiving that comment may be extremely offended by it. And the broader circumstances of the situation might support their feeling of offence because of other things that have taken place or because of the general environment in which that comment was made. So taking a comment in isolation, either saying it isn't harassment or it is really not helpful. We need to look at the surrounding circumstances and the backdrop to what has taken place. Very important to remember that intention is never really relevant, particularly in the case of sexual harassment. Simply saying I did not intend to harass, I didn't intend that comment or that behaviour to be sexual or racist, is not going to persuade an employment tribunal that it was not harassment. If the offence was taken and if the surrounding circumstances support that offence, then the complaint is likely to be successful. So who's protected in the workplace from harassment? Again, this is very wide. Employees in your business, people who are working under employment contracts, are protected, but so are workers. So they might be casual staff, interns, or people who work under umbrella arrangements to work 0 hours, for example. Apprentices, job applicants, so people who come to you and apply for work, who may be interviewed by you, and also former workers who might complain after they've left about receiving a reference that is in some way offensive or demeaning about them. Agency staff are also covered, and so are self-employed consultants who may work alongside your business. So that definition of people is extremely broad, and it sometimes catches out employers who think that they're only liable for what happens to their own employees who they pay through payroll. I want to mention victimisation for a second now. I said I would come back to it. We cover harassment and victimisation. I'm only going to mention it now, but it is relevant to harassment because under the Equality Act, if a worker or a former worker or a self-employed contractor, any of these people I've just mentioned, complains that they have been harassed by one of your employees, one of your representatives, and then as a result of making that complaint, if they feel that they have been treated badly by you, by your business, they've suffered some kind of disadvantage because they made the complaint, that would give them a good potential claim for victimisation. So victimisation is a legal claim on its own, a standalone claim that can be brought by anybody who says that they have complained about some kind of discrimination, including harassment, and then as a result of that complaint, they have suffered some kind of unfavourable treatment. So that makes it really important to ensure that if you do receive a complaint of harassment or some other discriminatory behaviour in the workplace, you deal with it seriously and you don't take any recriminatory action against the person who complains. You don't you don't lash out at them and treat them badly because they made the complaint. That would cause you more legal problems and possibly increase the risk of a victimisation claim. So who can be liable for harassment at work? Well, your business, whether it's a limited company or whether you're a sole practitioner who employs people or a partnership, whatever the identity of the employer in your business, that the employer is liable for the actions of your staff. So there's a term, a concept in employment law called vicarious liability. You as the employer are liable for the actions of your staff. So whether that's harassment or some other kind of discrimination, you take responsibility for what your employees do. You are not responsible for the actions of third parties towards your staff. So that might include things done by your customers, your suppliers, visitors to premises, service users, any other third parties that your staff have day-to-day or ad hoc contact with. They are third parties. If they harass your staff in any way, you as the employer of your staff are not liable for those actions currently. The law is likely to change on that in the next couple of years, and we will wait to see if the government's proposals do in fact come into effect. But currently you are not liable for third-party harassment. So coming on to then the legal duties on employers and defending claims. So you are liable for your staff and what they do to their colleagues. And if a claim is brought for harassment, whether it's sexual harassment, racial harassment, disability harassment, age-related harassment, if one of your employees or workers complains to the employment tribunal of a harassment claim, then you will be liable to pay damages if that claim is successful. And those damages could be quite sizable, depending on the seriousness of the offence and how much it has impacted on the person who complains. You will only be able to defend that claim if on one of two grounds. The first is that the harassment didn't take place. So there may be a situation where the claim is based on a he said, she said basis. So there may be no witnesses to the event that took place or is alleged. One person complains that there were harassing words or behaviour, and the other member of staff denies doing it. Nobody witnessed it, and the complaint doesn't succeed because the tribunal doesn't believe it took place. So that's the first way in which you could defend the claim, no liability. The second way you could defend the claim is, of course, if the tribunal accepts that the incident took place, but it doesn't accept that it meets the definition of harassment in the Equality Act. So there was some kind of unpleasant incident, but it doesn't meet the legal test. There is a third way that you, as an employer, can defend the claim. If the claim is successful, so it's established that the complaint is good, there has been workplace harassment, and there has been some kind of injury, impact on the victim, there will be an award of money attributed to them, made in their favour. But you as the employer could defend that claim on the basis that you are not vicariously liable. In other words, you're not expected to take responsibility for the actions of the offending party. So you'd have to make sure before you even start on trying to defend the claim, when you first know about it, that you name that party as responsible for their own actions. So that's something you have to do very early on in the claim. And then you've got to marshal your evidence, make sure that you've got a good enough case to be able to defend the claim on that basis. And that brings me on to how you would defend the claim. So to escape vicarious liability for the actions of your harassing employee, you have to run a defence that says that you took all reasonable steps to prevent the harassment from taking place. Now, that's a very, very high threshold to meet, and it requires very, very good evidence. It's rarely run successfully, and in a number of cases, if you care to look online, you'll see that it's not run successfully for very, very good reasons. So, some examples of why you might not be able to bring that defence and avoid vicarious liability include not having a policy on harassment, not having an up-to-date policy. So you might have a policy that's 10 years old. If you want to rely on that, forget it. You must keep it up to date. Not following your policy. So if the policy says you train your staff when they join you and you keep training up to date, if you're not following that policy, then you will not succeed with your defence. If you have no training in place, whether or not you have a policy, if you don't train your staff on what is and isn't acceptable workplace behaviour and on what harassment means and what victimisation means, then it's unlikely you'll be able to succeed with this defence. If you don't investigate complaints, if you brush them under the carpet, if you turn a blind eye, if you don't discipline offenders when complaints are upheld, these are all things that will bring down your successful defence. So, really, really important that you take preventative action. And this brings me on to sexual harassment, which is a special case. Now, the law on sexual harassment hasn't changed within the last 15 years since the Equality Act, but it has been updated. So the law on harassment on sexual harassment is exactly the same as any other protected characteristic. So it has the same legal definition, except the behaviour has to be of a sexual nature. However, because of the Me Too movement and various high-profile cases in the news, we can think of Weinstein, we can think of Harrods, we can think of the BBC and other high-profile employers, and inquiries into workplace sexual harassment, some very high-profile offenders. Because of all of this, the law in the UK has been updated in 2024 to place a new legal duty on employers of any size to take preventative measures to stop sexual harassment in the workplace. And the aim of that law is to change workplace culture for the better, to stop us uncovering cases like Harrods, which go on for years and are never nipped in the bud. So a new dawn, new workplace culture, cleaning out the toxic behaviour and ensuring that people feel able to come forward, make complaints and know that they'll be addressed effectively. So the new preventative duty came into effect in October 2024, and it says that employers must take anticipatory action. That is, don't wait for a complaint. You must be looking at this in a forward-thinking way to identify risks and risk areas for your staff, to take measures to address the risks, reasonable measures that are suitable for your workplace and that are affordable for you and that are effective. And having policies and procedures in place is part of that, but not the whole picture. So a lot of detailed work to be done is already being done by large employers, but in small businesses, this is something you may not have got to grips with yet because you're not sure quite how to approach it. A good starting place is the Equality and Human Rights Commission website. They produced updated guidance in 2024 to go along with the new preventative duty, and that sets out in great detail what this duty is all about, the things that you need to have in mind, the priorities that you need to start thinking about, and what to do a step-by-step approach to get to grips with this duty and compliance with it. It isn't something you'll be able to do overnight. It will take time, and you'll need to have a framework in place if you're going to take it seriously. But getting started is the first step. So, on the practical steps to handling issues effectively and lawfully, I would say start with your policy. Do you have one? Is it up to date? Does it even mention the new preventative duty? And does it tell your staff anything about how you will comply with that duty? If it doesn't, then that's the place that you need to start. And you need to start also then go on to think about how that policy can effectively reflect your workplace. So being in a big logistics warehouse and the kind of risks that that is going to pose for staff to sexual harassment is going to be very different to being in a hospitality environment dealing with customers in the late evening. So think about the workplace and think about what risks that throws up. Draft your policy to reflect those risks and keep an eye on monitoring and detecting harassment as you move forward. On to our next slide. I'm going to bust some myths about what is and what is not harassment. And I am going to start with banter. Now, many years ago, banter was seen to be acceptable in the workplace, and for many people it still is. But the word banter itself has become a little bit outmoded. I think that younger people probably don't use it in the same way as the older working generation. In the olden days, when sexual harassment was more commonplace than it is today in 2025, banter was seen to be acceptable, and often employers ran it as a defence to a sexual harassment claim. That does not wash anymore. Employment tribunals are not interested in defences that it's only banter. However, if your workplace does have a culture of banter, it's really important to be very clear about what is acceptable banter and what isn't. We all know that the workplace can be a dull and sometimes a hard and challenging place, and that jokes and light-hearted conversation get people through the day, and that is absolutely fine and acceptable. What staff need to be clear about is when banter strays into unacceptable harassment or discrimination. My second myth is, well, it can't be banter because the victim didn't complain about it. In fact, they joined in. There's a very famous case which was in the news quite a few years ago now. It's called Munchkin's Restaurant. And in that case, a number of waitresses were working with the owner of the restaurant. The owner of the restaurant used a lot of sexual language and banter. They didn't complain, and they, in fact, joined in with the kind of language and the conversation that he enjoyed. And he ran the defence that it can't be harassment when they brought their claims, but their claims succeeded. And the tribunal, and I think the Employment Appeal Tribunal in that case, said, well, it doesn't matter always that a victim doesn't complain, and it doesn't always matter if they join in, because we need to look at the context of the relationship between the parties. And here we had junior staff, younger, considerably younger than the owner, who didn't feel it was their place, didn't feel that they could complain, and felt perhaps fearful that they were going to lose their jobs if they did. So their safest sort of protective mechanism was just to go along with his behaviour. So not complaining will not defeat a claim of harassment. And sometimes people are under the misconception that a one-off incident, a one-off comment can't be harassment. There needs to be some kind of course of behaviour. It needs to go on a while. It needs to be a campaign. Well, that isn't correct. If you look back at the definition that we talked about earlier, it's broad enough to include persistent behaviour and also one-off incidents. Now, it might be that a one-off incident doesn't persuade the tribunal that this is very serious harassment, and that might be reflected in the amount of money they're prepared to award the victim. However, a very famous case, and I'm going back to the mid-90s now, established the principle that a one-off incident comment is enough. I'm not going to say the comment out loud, but there was a one-off comment about the female anatomy, and the case hinged on whether that in itself could underpin a good harassment claim. The Employment Appeal Tribunal decided that it could. And so beware, if your member of staff comes to you and says, this comment has been made to me, don't brush it away and say, well, that's not serious enough. Take it seriously, investigate, make your own mind up, and be seen to act accordingly. And finally, on this page, only managers can harass juniors. Well, of course, that can't be correct, can it? In a lot of cases of harassment, we see the power relationship at play, and the power dynamic of influential people in powerful positions behaving with impunity. That certainly happens in the Harrods case, for example. But it isn't true that it can only happen that way around. And of course, it will depend on the nature of the relationship and the circumstances surrounding what took place as to whether it would be harassment if the tables were turned. And a few more myths on the next page. No offence meant, I'm not a racist, I'm not sexist. I have friends who are from different ethnic minorities. So this is often something that I've heard when I've interviewed witnesses about an allegation of harassment against them. Well, it may be that in outside of the office or outside of the workplace, somebody does have friends who are of different ethnic minorities, or women who are disabled, but that isn't a test. The test is how did they behave in the workplace, and we know that people can be very different outside of work to how they behave in the workplace. So tribunals most of the time not interested in what people do outside of work unless it is brought into the workplace in some kind of some way. Obviously, if there is some predilection, some evidence of an individual being particularly racist in their day-to-day life, that of course could support the fact that if they say they're not a racist, that's discredited. But in terms of what takes place at work, simply saying that's not me, I'm not a racist, I'm not sexist, that's not going far enough to defend a claim. Compliments are not harassment. Well, we thought about a few compliments earlier that clearly could be taken the wrong way. And of course, if they are, then a tribunal will be prepared to consider whether they are harassment. The context will be considered, and whether that party was genuinely offended by the compliment, whether it was perceived as a compliment or as something more offensive, would be part of the mix in any hearing of the claim. Only women can complain of sexual harassment against men, not the other way around. No, that's not correct. Sexual behaviour can cut any way. It can be against a woman, it can be against a man, it can be against a same-sex person. We can't assume that this just goes in one direction. And only the victim's viewpoint counts. Well, as I hope I've demonstrated, that isn't entirely accurate. The victim's viewpoint is the starting place, and the subjective test is important, but the objective test, whether it was reasonable for them to take that opinion, take that view of what happened, will also be looked at and evidence will be considered. And so, my key takeaway for today is here on the slide. Proactive compliance prevents harm and protects your business. So, your legal duties are something you can't avoid as a business, whatever your size. By taking some proactive steps, whatever they might be, and having evidence of those steps will help you to demonstrate that you've complied with those legal duties. If you don't take any steps at all, you won't have a chance of demonstrating that to the Employment Tribunal. And at the end of the day, the introduction of the preventative duty is about preventing harm for your staff so that they can thrive at work and do their best work and support your business and its growth. If they do not feel that they're protected and safe at work, then they're either going to leave or you're going to have grievances, and that will take away from your business growth and success. So it's preventative. It protects your business from legal liability, but it also protects your business from having to deal with issues that will take away, distract from your main priorities, which is succeeding in doing what you do and growing. And final takeaway is that a safe workplace is a productive workplace. I'm sure we would all agree with that. And I did say I would give you some useful resources to take away. So we've got a list of them on screen. The ACAS Code of Practice is always useful. That's on disciplinary and grievance matters. Of course, you may have to use both disciplinary and grievance if you're dealing with complaints of harassment. So those are processes that you need to be confident in. The Equality and Human Rights Commission technical guidance for employers, as I mentioned earlier, take a good look at that if you are interested in what you need to do to comply with the preventative duty. ACAS guidance on the preventative duty is also available. Check out our YouTube channel for our resources, such as previous recordings of HR Lunch and Learn topics and our Healthy Workplaces podcast. And finally, if you've attended this webinar, you will get a free sexual harassment checklist from us, Burley Law, to use in the future. So I hope you found that useful. Don't forget, our Lunch and Learn series continues on the 17th of September, and there we will be focusing on what you need to do to bring employment to an end. Here at Burley Law, we offer starter and scale-up HR bundles. Now, these are very helpful bundles of documents to get you started or to refresh your HR documentation. Our starter bundle is perfect for new businesses with up to 10 employees, and our scale-up bundle, which you see on the screen here, is for growing businesses who have more employees up to around 50. So there in those bundles you will find contracts of employment, an intern agreement, company policies, starter forms, non-disclosure agreements, and they both come with 6 months ongoing support with our team for any day-to-day legal queries. Do get in touch with us and our marketing at Burley Law if you're interested in having more details. And finally, thank you for attending. I have been your host, Liz Burley. This has been our HR Lunch and Learn on harassment, and I look forward to seeing you next time.